All right, so away we go. Some people are still joining us. So we're going to start at the beginning because there's no better place to start, which is, if you're planning ahead for the future, one of the most important things you need is to have your estate planning in place. And a lot of people ask me, well, what is that exactly? And so it's the process by which you get your financial affairs in order and your assets. You understand how your assets are titled, which is a really important thing. That when we're working with clients, most of the time they come in and say, I think I need a will. And we say, you probably do. But we also want to look at all of your assets so that we understand what type of asset they are. Do they pass by a will? Do they pass by beneficiary designation? Are they joint? If they're joint, who are they joint with, right? If you have 5 kids, and you've made your account joint with one of them, that can be a problem. So asset information, although clients are usually hesitant to provide it, for me, it's really the whole ball game. I can't do a good plan, and you can't have a good plan if you don't share your financial information. And to the extent you limit what we see, your plan is going to be not so great. So, the most important thing that you can do is really have a power of attorney. A will is good, but you want the general durable power of attorney as well. This is going to give you some control and some feeling of peace of mind that if something happens to you, you have made the decision about who is going to handle your affairs. So, a lot of times people ask me, well, what if I do nothing? What happens then? I'll tell you, it's not great, but people who fail to plan to fail, right? That's a common saying in our profession. And what can happen is if you haven't made any arrangements, you can end up in the orphans court, the subject of a guardianship action, where family members, and maybe not even one you like, can try to become your guardian and become the sole person who can make decisions about your assets and about where you receive care, where you live, and things like that. I think most people would find that horrifying. So, as much as nobody wants to do estate planning, same as you don't want to go to the dentist, it's just something that you have to do. And if you know ahead of time that your kids don't get along or the people you're going to leave things to don't get along. Planning really is about trying to prevent any future disputes that could arise. So making sure that you understand, who you want to name, communicating that to people, giving things now. If you know you're not going to use it anymore and you know it's going to be something that somebody's going to create a stink about, just give it to them. And then the other issue is unnecessary taxes. And we'll get into this, later on, but people do all kinds of things sort of on their own, maybe using Google, maybe using now Chat GPT. And the robots are not yet equipped to give you legal advice. And so you want to be really careful relying on information from anyone other than an attorney, because a real downside can be unnecessary taxes, and we'll talk about that a little bit. Okay. So now that we sort of understand generally what estate planning is and why we should do it, what are the components of it, right? So a great set of documents would include not just a will, but a general durable power of attorney for finances, and this is the person you will name that will be able to help you with all manner of financial transactions. And even, if we're worried about you becoming ill and entering a nursing home, they're even able to do Medicaid planning for you. So it's a really powerful and important document, the power of attorney, and should be carefully drafted, not just pulled off the internet, because there are key provisions in a power of attorney that under Pennsylvania law need to be in there if you want your agent to be able to do planning for you. And when I look at documents from the internet or prepared by people who don't routinely, maybe lawyers, but don't routinely prepare powers of attorney, the documents are insufficient for what the client needs. And in some cases, our client at the time, or the person who's seeking to become our client, doesn't have the capacity to do a new one. So getting it right is really important here. Let's talk about healthcare. Everyone should have a healthcare power of attorney and a living will. The living will is not a last will and testament, and the healthcare power of attorney is not a living will. They're two separate things. So let me explain. The healthcare power of attorney is where you are naming somebody who is going to make healthcare decisions for you in the event you are not able to communicate your wishes to your physician. So this needs to be somebody that you trust to carry out your healthcare wishes. It may not be the same person you pick to be your agent under your financial power of attorney because the skill set for those two jobs is quite different. It can't be, but it doesn't have to be. One of the things that I've noticed doing this for more than 20 years is that clients oftentimes don't give enough time and thought to who they want to select as their agent. And really, it's one of the most important things that you can do. If you know that your eldest son, for example, isn't great with money, right? Has financial problems, is in the middle of a lawsuit, is seen in the middle of a messy divorce, things like this. You don't want to name that eldest son your agent under power of attorney. And we can work with you to how to communicate that to someone who might be disappointed. It's really about picking the right person for the right job. But turning back to healthcare, again, the healthcare power of attorney is where you're going to name the person who would make the same decision that you would in a given situation, that they're going to stand in your shoes and make the same decision you would, not the decision that they would make. If you have a worry that somebody's going to override your decisions as to your treatment, that's not the person to pick. And your agent might not know, they might be able to follow your instructions, but they might not know what those are. So, in addition to doing the document, you've got to talk to your healthcare agent to explain to them your preferences for healthcare treatment, places you don't want to receive care, this hospital, not that hospital, this nursing home, not that nursing home, this therapist, not that therapist. Really get very detailed with it. Your agent will need that information if they're going to fully stand in your shoes and do a good job for you. So the living will can be a separate document. We've done it as a separate document. We now do it as a combined document with the healthcare power of attorney. And this is your statement as to what treatment you would like to receive at the very end of life. So there's this idea of having a good death. And for most people, having a good death means outside of a medical or clinical setting, maybe at home, maybe with friends and family around, peaceful, no pain, right? No discomfort, right? And that can sometimes not be the case, right? Your wishes can be at odds with what happens in a clinical setting. So having the living will empowers your healthcare agent to carry out your preferences for having a good death, again, as peaceful and pain-free and quick as possible. Now, Pennsylvania allows you to kind of spell out in detail your wishes for end of life treatment, and if you have those preferences, you can put them in a living will. Some clients, and you might be familiar with the 5 wishes document, which goes into even more detail and can be a companion to the living will and healthcare power of attorney. It could theoretically, the 5 wishes, stand on its own. My concern with that is it's not something that healthcare providers are used to seeing. Not everybody has one, and there's no legal basis for it. So having it in conjunction with your other documents, if you so choose, it's not necessary. But I have clients who have it and ask me, well, what about the 5 wishes? We can integrate that into your healthcare power of attorney and living with. Another question we get a lot is, well, what about an out of hospital DNR or a PULSE, physician's order for life sustaining treatment? Where do those fit in? Those are both doctor's orders, contrasted with the healthcare power of attorney and living will, which is your statement that you get to write up about what healthcare decisions you want made and what you want your end of life to look like. When you do indeed get to the end of life, you would think about doing the out of hospital DNR if you're not in a facility, or the PULSE form. Again, both of those come from a doctor or the provider. So your healthcare power of attorney, living will, everyone should have one, even people who might be on this call who are a little bit younger. It's not just for the elderly. We never know, unfortunately, when a disaster is going to strike. So you want to make sure that you have your plan done, that you've done the healthcare power of attorney and living will, and that you talk to your agent about what decisions you want made. And then I'll point out, sometimes people ask me about the PULSE. Right now in Pennsylvania, there is no statutory authority for the PULSE form, that physician's order for life-sustaining treatment. So how does it get used? Who has to honor it? We don't know, actually, right? There has been legislation pending for years. It just keep getting reintroduced year after year, because it is so critical that we have a statute like other states, but it keeps getting hung up in the important conversation about if we allow people to say they want to pass away and have no artificial invasive measures, is that interfering with God's plan or some other thing? The religious organizations have their point of view, and they have been sort of the stumbling block, if you will, to getting legislation that other states have with respect to PULSE. So while that's still being ironed out, you want to make sure you have a great healthcare power of attorney and a living will. The last item on the list is a living trust versus a will. Both a living trust and a will are what we call testamentary documents, right? They speak at death, but a living trust can also, as the name implies, speak during life. And it is a document that sets forth what happens to the assets that you place inside of your living trust during your lifetime and then at death. A lot of clients call me worried that they think that they need a living trust because they've seen an infomercial, maybe Susie Orman selling trust kits, 11 p.m. if you're still watching television. And it makes it seem like we need one here in Pennsylvania. The answer is that any planning document is valid on its own, but whether it's right for you is something for you to discuss with your legal counsel of choice. My general guidance to folks who live in Pennsylvania is that, absent other circumstances, you don't need a living trust, and you especially don't need a living trust to avoid probate. Probate is the term for after you've passed away, getting your original will accepted by the county register of wills office in the county where you passed away. In some states, that can be challenging or time consuming or expensive or a combination of all three. And so that's why in those states, living trust to avoid probate can be important. In Pennsylvania, probate is neither time consuming, expensive, or complicated. An example I give all the time, and it is a true story. I did a probate appointment with my client. It was during the pandemic, but I was in my car in a Wawa parking lot on a cell phone in one hand, Wawa hoagie in the other, and we did the appointment in under 5 minutes, and that was probate. Pennsylvania probate is designed to be easy. It is not one of those states where you need to worry about probate avoidance. And it's also not a state where you want to think about putting transfer on death or TOT or payable on death or POT on all of your accounts so that everything avoids your will and avoids probate, right? How you title your assets, as I said a few minutes ago, is really the whole ball game. And so your estate planning is not just a set of documents, but marrying it with the titling. And like I said, right now, ChatGPT and Google aren't going to get you to connect those two things, aren't going to connect what your family dynamics are, or who you should be picking as your agent, your executor, maybe a trustee. So again, this is really something you should be doing, with a lawyer to make sure it's done correctly. Keeps you out of the courthouse for guardianship, keeps you out of the courthouse on a petition to fix a botched will and things like this. I always ask this question because I think I always worry that families will think, oh, my loved one's been diagnosed with Alzheimer's disease. I guess that's it. We're stuck. We can't do anything. And the answer is that is not true. Even people with early stage Alzheimer's still retain the level of legal capacity to do a will, a financial power of attorney, healthcare power of attorney, living will, etc. But that's something for the lawyer to determine in consultation with the client. The diagnosis itself isn't a bar. Sometimes if somebody's waited a long time, it can be. But don't think just because someone has been diagnosed, is having trouble remembering things, that means they can't do it. There are different levels of legal capacity for the different documents, and it's up to the lawyer to determine whether the client can still retain or still has that decisional capacity. Why do we think that's important? It's that bullet point there, self-determination, right? I think everybody who thought to join a call like this understands the importance of self-determination, meaning you get to pick who your fiduciaries are, who's your agent that's going to make financial decisions for you, who's your agent that's going to make healthcare decisions for you, where does your stuff go when you pass away. The ability to make those choices for yourself is so critically important that we want to make sure that even people who have a diagnosis are evaluated to see whether they can reach the levels of legal capacity that are required to do the different documents. So I have alluded to this. So estate planning done well is tailored. When it starts with a complete and accurate asset list. When we're working with clients, we help put this together for you. We look at all of your statements, your beneficiary designations. We make sure that there's a coordination between where you want things to go for assets that pass under your will and assets that pass by beneficiary designation. In some cases, we might recommend a living trust, not for probate avoidance, but for other reasons. But this stuff is not a one size fits all. So I've had, clients come to me for a consultation and they say, well, I just did what my sister did, right? I just literally sat there and typed up from her documents, right? And then when we get into it, we realize that the assets are completely different, the family dynamics are completely different. So you really can't just take a will from somebody else, type it, swap out the names, and be good, right? That there's a lot that goes into this. So much so that almost every client that works with our firm and works with me says, "Oh, I hadn't realized that. Wow, this is more complicated than I thought," right? Um, Hopefully, when we're working with you, and the reason we do these webinars is that we want to educate people to get the advice that they need so that they get that self-determination piece honored. So, and then if any of these situations, you're looking at this, the right for conflict list, if you're like, oh, this is me, you definitely want to meet with a lawyer to go over your situation. Blended families is a big one. Lots of people, even older adults, are getting married in their 70s and 80s. You know, if you want to have fun Googling later, you want to Google gray divorce and golden marriages, right? You're gonna find out that there's a lot that's written on these topics because um, there's a lot of ageism out there, and there's this assumption that once you reach a certain age, like things like marriage and partnership and love, like you don't either care about it or need it, and that could be further from the truth. The data is showing that people, regardless of their age, are getting divorced, getting remarried, and yeah, different families. You might love your new partner, you might not like your kids so much, and vice versa. So the planning for these kinds of things can be really critical, and looking at things like prenuptial agreements. And so really you want to think about that. And you want to think about unequal distributions between children if you're planning on doing that, or you're fearful about doing that. So I have clients who may have taken care of one child a lot more, but when it comes time to doing the will, they want to leave everything equal because they will say, well, I don't know how to word it. That's what the lawyer is for. So we can talk you through how to prepare a document that can address unequal distributions and prior gifts and loans. That comes up a lot. We've talked about financial powers of attorney on a prior slide. I just want to hit on this slide the idea of a springing power of attorney and what that is. So, a springing power of attorney is one that does not come into being until you become incapacitated. And the determination of incapacity is in the opinion of usually two medical doctors. And while that sounds good to some people who are worried about their agents acting too soon, what the reality of it is that, in particularly, we're talking about planning ahead, preparing for the unexpected. That when suddenly you have an accident or something and you have a springing power of attorney and your agent is sort of thrust into having to help you out of the blue unexpectedly, the reality is getting two doctors to say that you're incapacitated so that the agent can act is very difficult to get. And over those days, weeks, and sometimes months, while the agent is trying to get those doctors' notes, nothing can be done for you. Right? So, as a rule, I never do springing powers of attorney. I don't draft them. I've only gotten the calls from people who are the agents thrust into the situation, crying, why did the principal do it this way? So, what you can do instead, if you're worried about your agent acting too soon, well, one, we need to have a conversation of, did you pick the right person? And if you did, then you can hold back a piece of the power of attorney that's called the agent acknowledgement, and just tell your agent, I'm going to hold the document, and when it's time to act, when that unexpected thing happens, then you can sign the agent acknowledgement, and that's all that's required for you to be able to act. You don't have to worry about two doctors getting involved. Um, and then I usually counsel clients to pick one person. It does make it easier, and that one person can keep everybody else informed. There are some banks that are starting to not honor two people. Sometimes we do two people if it makes sense. But the better approach I have found is really just to pick the one that you know is going to be the most proactive, that's good with paperwork, that has the time to do it, and have the next eligible candidate be the backup. We've talked about the healthcare power of attorney. So on this slide, I just want to draw your attention to a resource that I really like in terms of planning ahead and preparing. It's called the Conversation Project. The website is conversationproject.org. If you want to Google that later. So while most people think their data shows that while most people think, yeah, it's important for me to talk to my family and loved ones about my wishes for healthcare and end of life treatment so that I can have a good death, only 30% of us have done so. And the idea of the Conversation Project is, well, why do people not do it? And the thought was, well, maybe they don't know how to have the conversation. So this project was born to give people resources, tools, tips, tricks. How do you have the conversation about a really, I think most of my clients find it depressing, not everybody, on this or a scary topic, right? So it gives you sort of conversation openers that you can really be one of those 30%. Hopefully, there are more people are doing it now that are having these conversations. Okay. Now move on to trust, because I know most people, when they think about, particularly as they're moving through life, they're seeing parents and loved ones age, maybe move into care. They start thinking about asset protection. And when you start Googling or that kind of thing, a topic that comes up most often is trust, right? And so the thing to know is not everybody needs a trust, and that there are all kinds of trusts out there. And so this is another reason when you're thinking about doing planning that you want to make sure that you get the benefit of the advice of what kind of trust is right for me. But sort of foundationally, a trust is a legal arrangement where you're moving property into a trust that's managed by a trustee for the benefit of a beneficiary. The document creates the specifics, but you have to put the assets in. And we say that a couple of times because it's pretty common that clients might maybe even go to LegalZoom or whatever, draw up the trust and think, I've done it. I've paid Susie Orman her, $49.95 and I'm good. And the answer is no, you're not. You need to fund the trust. But before you fund a trust, you need to make sure it's the right thing to do because it can have downstream effects for things like Medicaid eligibility, right? So it's not something to undertake lightly or to do on the basis of things that you get off the internet. Just wanted to include in the material some key terms just so you know when you see them. A grantor, trustor, settlor, that's the person who creates the trust. The beneficiary is simply, I think we all understand what that is, a person who's going to benefit from the trust. We can have two levels of beneficiaries. We can have beneficiaries who receive the assets when we pass away, right, for their lifetime, and then remainder beneficiaries who get it when that lifetime beneficiary passes away. And then we can have a trustee. This is, can be a co-trustee, it can be an individual, be a bank, it can be a trust company. You can have an order of trustees. There's a lot that goes into it, but these are the terms to be aware of. Apologies. So for revocable and irrevocable trust, before you do any of this, you need to understand the legal and the tax consequences. So the legal consequences can be pretty uh, dire, if you're not mindful of what you're doing. And the tax consequences tied up with that. You can, for example, if you've moved property, of the family home into a trust, right, and you didn't pick the right kind or it doesn't have the right language in it, you can end up with a loss of a step up in basis and a big capital gains bill when the person passes away. You can end up with a lack of control if you're the property owner, right? There's lots of things to be aware of that are too numerous to get into in a short webinar, but before you just go do the thing that the internet makes it seem like it's so easy to do, right? Or do the thing that your neighbor said, hey, I did this, you should do that. You really need to meet with a lawyer to have your suitability for a trust analyzed and that you understand all of the legal and tax consequences to doing that. But just going through, again, what is a living trust? It's one that you create during your lifetime. You're able to revoke and amend it. You maintain control over your assets. It is not used for asset protection. And I kind of drew that out because so many clients think that, oh, I've planned for future Medicaid. I've put all my assets in my Susie Orman Revocable Living Trust. And because you can still control the assets, you can revoke and amend the trust, there is no protection there for Medicaid. Medicaid looks at any circumstance under which you can make the resource available to yourself. It's countable for Medicaid purposes. So a revocable living trust doesn't work. And when you transfer your house to a revocable living trust, your house loses its uh, qualification as exempt resident property, right? So people do it to avoid probate because they're worried based on what they see on the internet or hear that, oh, I need to avoid probate. Hopefully, I've dispelled that myth. But the idea is that it doesn't generally do what people think it does, which is for um, asset preservation, but it can be a nice way to plan for future mental disability. It works nicely for clients that are solo seniors, right? That have wealth, and we can fund our trust with maybe their favorite, bank as the trustee. Lot that goes into that, but that is something that can be a good use. If we have clients, they don't have a Medicaid worry, but this stuff again isn't one size fits all. But for me, when I'm doing these webinars, I try to dispel as many myths and things that people do, thinking that they're getting a good result based on things they see on the internet. An irrevocable trust, by contrast, is one where the terms can't be changed, and generally speaking, the grantor does not retain control of the trust assets. Now, these trusts can be used to reduce your taxable estate. I'll get into that in a second. Do asset protection, qualify for public benefits. If you have a 5-year window, okay? So irrevocable trusts and the Medicaid asset planning world, right, are the type of trust, unlike a revocable trust, that work for asset protection. But you need 5 years window before that you need to qualify for Medicaid for it to make sense, right? So A lot of times people don't plan that far ahead. Sometimes they do. Some common types in that space are what's called a MAT or an IOT, a Medicaid Asset Protection Trust, and an irrevocable income only trust. Those are types of trusts that are used in that 5-year look back period. A VAP is a Veterans Asset Protection Trust. Again, done for the 3-year look back for VA benefits. We can also have things like supplemental needs trust, life insurance trusts. There are all kinds of different irrevocable trusts. Now, the news has been filled lately with the One Big Beautiful Bill Act. I'm sure we've all heard about it. So there's lots, it's a huge bill. The component that I just want to touch on relates to one's taxable estate. For the last several years, planners like myself have been talking to clients about the great sunset of the federal estate tax provisions that in 2017, the Tax Cut and Jobs Act had put into place a $5 million exemption index for inflation. And then that went up to, for this year, 14 million, it's like 13.99 million. And then it was set to expire at the end of this year. And so we've been talking to clients about, oh, it's going to expire, but worst case scenario, it goes back down to 5 million index for inflation, and it'll end up around 6 or 7 million. With the One Big Beautiful Bill Act, that's all gone away. It's made permanent a $15 million exclusion per person. So that's now permanent, not sunsetting. Index for inflation. So it's only going to get bigger. So what does that mean for most of us mere mortals on this call and most clients that we serve is that you're not going to have a death tax worry, at least as relates to federal estate tax. Most people that don't have $30 million. There are people that do, and that's great. And there's still planning that needs to be done. But most people under the change in the law don't have a worry there. So just in terms of, we'll get to questions in a minute. Protecting your assets. Again, having a good financial power of attorney and training your agents so that they're ready when the time comes, if the time comes, is the best way to prepare for the unexpected. So again, I won't sort of read you what's on the slide because I think I've covered that in my remarks so far, but it is really very important. So again, it's not just the will, having the financial power of attorney, and the will and the healthcare power of attorney. And then I just want to pivot into a little bit of our firm's approach. We are a life care planning law firm, which means we do estate planning, but we also do estate planning married with care planning. So it is a specialized area of the law that marries, again, estate planning, disability planning, and it looks at coordinating with where you are on the plan of care and what public benefits are available to you. I really like this chart because I think it sort of sums up the continuum of care and how it gets paid for. And the idea is that most people who probably are on here are at the far left. They're at home doing okay, but maybe we have some adult children on here whose parents are moving along the continuum. And as you can see, as you need to consume more healthcare needs, things get more expensive. So when we move along to the far right hand corner, we're looking at the nursing home and the ability to trigger Medicaid once you cross the threshold of a nursing home to get assistance paying for your health care. But as you look along the bottom row, we have, using unpaid caregivers, your own assets and income. Hopefully you don't have to hit up your kids for money, but that does happen. Long-term care insurance, if you have it, it's getting harder and harder to come by. There's less companies selling the types of policies that I see routinely where you pay a premium in exchange for coverage. What we're seeing more now are hybrid policies that are combined with life insurance, where you pay a very large lump sum in exchange for benefits. But it is a good benefit to have. Medicare, VA, things like this. Um, this is just letting you know that they're, again, sort of putting it in a different way. The different payment sources with the level of care, and the Medicaid number has actually gone up for waiver. It's 2931. I forgot to update that when I was updating the slides. If you're somebody at home with gross income below 2,931, they might qualify for Medicaid at home. If that's you, that's something you definitely want to talk about. And we have 1 minute left. I want to kind of go through this slide because so people look at the assets that are on this slide and think, well, I'll never qualify for Medicaid. I need to, and then maybe the nursing home has told me I need to get rid of all my assets before I can qualify. And the answer is actually, if this is a married couple case, we can qualify somebody for Medicaid. What you need to understand is that the nursing home or others are not legal advice, right? That while yes, you can divest your assets over a long period of time and then let the nursing home help you when you've gone broke, apply for Medicaid, that actually you can be proactive. It's never too late to plan. So even a couple with assets that look like this can still, with the assistance of good counsel, qualify for Medicaid. And a final myth I want to dispel is if you go to a Medicaid facility, it's a bad place, right? That is not true at all. Lots of great places accept Medicaid as a form of payment for long-term care costs, and lots of not so great places don't take Medicaid, right? So that is not an indicator of the quality of the facility, whether or not they take Medicaid. You want to look at Pennsylvania. Office of Long-Term Living maintains a database that's kept up to date with nursing home ratings, as well as the Center for Medicaid and Medicare Services. They have a tool called Nursing Home Compare that does a 5-star rating and other metrics. That's really where you want to look to see whether a nursing home is a good one or a bad. And Allie, how are we at time? Is Allie still there?
Yes, we can just answer a few questions if you wanted to.
Okay, great. Let's do that.
Okay, the first question is, my estate includes an adult special needs child. They do have all the necessary documents and a third party special needs trust, but they are contemplating moving from PA to New Jersey. What did they need to update their will and their trust?
Yeah, absolutely. It's great question. So estate planning documents from other jurisdictions are given full faith and credit, right, in the home state. So they can't say, oh, your power of attorney is no good here because you did it in Pennsylvania. That being said, with the special needs planning, and if the person is on public benefits and will be moving to New Jersey public benefits, the rules are somewhat different. So it doesn't need to be the first thing they do when they move to New Jersey, but they should meet with New Jersey estate planning attorney, special needs attorney, to have all of the documents reviewed and to determine what needs to be updated. As to a third party supplemental needs trust, which would be one created by mom or dad, that wouldn't necessarily need to be updated. That would still be where mom or dad lives, and that should be fine and pass muster. It's really the individual with special needs should have their documents reviewed, potentially updated for the move to a new state.
Okay, great. And then just if you can explain again why you don't recommend to put the house into the revocable trust.
Sure. So a revocable living trust is not a great idea. Giving it to your kids for $1. The biggest thing that we see when clients do that is that the house loses its status as an exempt asset for Medicaid planning purposes. So the Medicaid office will treat your house as an available resource for your care and needs. So before transferring any asset into a revocable living trust, you need to understand that you're changing the character of it from a non-countable to a countable resource as far as Medicaid is concerned, right? And that you understand that you've done nothing. If your intention was that I'm going to protect it against long-term care costs, that is a larger, bigger conversation. And that if you do want to plan with that asset within a 5-year look back period, there would be an irrevocable trust that we would recommend for that purpose. But you never want to move assets into trust without the advice and guidance of an attorney who's looking at your whole situation, including what your healthcare needs are, both now and what we expect them to be in the future.